The Residential Real Estate Disclosure Advisory and Election READE form was introduced by the Arizona Association of Realtors, or AAR, as part of an effort to streamline and clarify disclosure obligations in real estate transactions. Purpose of the READE form. The READE form is designed to inform buyers and sellers about the various disclosures required in Arizona residential real estate transactions. Serve as a notice and acknowledgement rather than a disclosure form itself. Outline disclosure laws and resources, such as the SPDS, Seller's Property Disclosure Statement, lead-based paint disclosures, and other federal, state, local requirements. It helps agents meet their obligation to disclose material facts and ensures clients understand their rights and responsibilities regarding property disclosures. Background and timeline. Prior to the introduction of the READE form, the understanding of agency relationships in Arizona real estate transactions was evolving. By the early 1900s, Arizona courts recognized the agency relationship between brokers and clients, and by the 1950s, it was widely established that real estate brokers had fiduciary duties to their clients. Pre-2017, agents and brokerages typically relied on various standalone documents and broker-created disclosures to fulfill legal requirements. 2017, AAR standardized the process with the READE form, making it easier for agents to provide consistent and clear advisory notices at the beginning of a transaction. Present. The READE form is now commonly used in Arizona as part of the listing and/or offer packet and is updated periodically by AAR. The AAR regularly updates its forms to reflect changes in laws and industry practices. Updates are typically released on February 1st, July 1st, and November 1st each year. These revisions aim to minimize risks and ensure legal compliance for realtors, and their clients. Here is a look at the entire form of the READE. Despite this flexibility, there was a growing momentum towards exclusive buyer representation. However, major brokers, particularly in residential sales, resisted this move. Commercial and industrial brokers were quicker to embrace the exclusive concept. In August 1995, AAR introduced the Buyer-Broker Exclusive Employment Agreement, BBEEA, but its adoption among residential brokers and agents was hesitant. The reluctance stemmed from the requirement to establish an exclusive relationship, creating a binding contractual arrangement. In contrast to the READE form, the BBEA is a bilateral binding agreement, imposing obligations on both the buyer and the broker. Many agents were accustomed to working with buyers informally or under sub-agency, and the idea of requiring buyers to sign a formal agreement, especially one that addressed compensation, was met with some resistance. Over time, adoption increased due to greater emphasis on agency disclosure, risk management, and the benefits of formalizing the buyer-agent relationship. It is just that. The buyer or seller elects to have an agent work with them and discloses the nature of their relationship and the agent's authority and limitations. The Real Estate Agency Disclosure and Election form from the Arizona Association of Realtors, updated November 2024, is a standardized disclosure document used in Arizona to clarify the type of agency relationship a real estate licensee or broker has with a seller, landlord, or buyer-tenant in a real estate transaction. Here's a breakdown of the key sections. Page 1, Disclosure section. This portion informs the seller-landlord about possible agency relationships. 1. Purpose. Before entering into discussions, the seller must understand who the agent represents and the nature of the relationship. 2. Types of agency relationships. I. Buyer's broker represents the buyer exclusively. Owes fiduciary duties to the buyer. Loyalty, obedience, disclosure, confidentiality, accounting. May show competing properties to other buyers. 2. Seller's broker represents the seller exclusively, commonly under a listing agreement. Owes fiduciary duties to the seller. May have other sellers with similar properties. 3. Dual agency, limited representation. The same broker or firm represents both the seller and the buyer. must have informed written consent from both parties. Certain information, like how low a party is willing to go, cannot be shared without written permission. Creates potential conflicts of interest. 3. Broker's obligations to all parties. Must be truthful, honest, and use reasonable skill and care. Must disclose material adverse facts. Does not need to disclose natural death, suicide, crime, or HIV/AIDS status related to the property. Sex offender proximity. The form stresses that buyers and sellers must protect their own interests and read all agreements carefully. Page 2, Election section. This section is where the seller or buyer makes their official election regarding whom the broker represents. For sellers' landlords, only complete if you're the seller. You select one or more options to indicate the relationship you want. The broker represents the buyer only. The broker represents the seller only. A broker can represent both the buyer and the seller with limited representation if both parties consent. Clarification. This form is not an employment agreement. Compensation arrangements are separate and must be documented in a different written agreement. Compensation is negotiable and not dictated by law. Signature section. The sellers or buyers must acknowledge the disclosure of agency, initial and sign the form to confirm they received and understand it. Summary. This form ensures transparency in real estate relationships, protects both parties by disclosing potential conflicts and obligations, documents how a broker may legally interact with both sides of a transaction, must be signed early in the process, before serious negotiations begin. If you're a real estate agent, this form is a crucial compliance document. If you're a seller, it helps you understand who's working for whom and how that affects confidentiality and negotiations. Seller compensation. Addendum. Line-by-line breakdown. Header section title and branding confirms this is an official form created by Arizona Realtors. Document updated February 2025. Shows you're using the most recent version. Lines 1-5, identification. Who is initiating this addendum? One box is checked: seller, buyer, landlord, or tenant. Date the addendum is being completed. Buyer tenant name, individual, S, purchasing or leasing the property. Seller, landlord name, property owner. Premises address, property location referenced in the agreement. Lines 6-9. Compensation agreement statement, indicating this addendum is now part of the primary contract or lease agreement. Restates that seller agrees to pay compensation to the buyer's broker. Clarifies that this compensation may be credited to the buyer, either partially or fully, depending on how it's structured. Checkbox for compensation type. Sale. Seller agrees to pay the buyer's broker a percentage of the final sale price or a flat dollar amount at closing. Lease. If leasing, compensation is based on a percentage or dollar amount of the total lease value. Lines 10-12. Clarifications. Restates that the compensation will be paid at the close of escrow or the execution of the lease agreement. Indicates the percentage or dollar value is based on the total initial lease term if applicable. Important clarification: the amount agreed upon is in addition to any seller concessions, such as money for closing costs, already offered in the contract. Lines 13-18. Legal protections and intentions. A written authorization allowing the buyer-broker to be paid from more than one source, where applicable. 14-15. Protects the buyer-broker's right to be paid, even when another party is involved, like a builder or relocation company. Direct third-party beneficiary language. Seller and buyer expressly allow the broker to enforce payment terms. The broker is a third-party beneficiary of this addendum. Legal reference to Arizona Purchase Contract Section 8F or Lease Section 9F, supporting enforceability. Clarifies that this agreement survives closing, meaning the broker is still owed, even if compensation is delayed. Lines 19-25. Additional terms. 1925. Blank space for any custom or additional terms the parties wish to include. Lines 26 to 32. Signatures. Signature blocks for all parties, seller, buyer, landlord, and tenant as appropriate. Dates are recorded to confirm when each party signed. Bottom section, for broker use. Only internal fields for managing brokerage documentation, file log number, managers and brokers' initials, date of broker's review, purpose of the form. This addendum provides written proof that the seller agrees to compensate the buyer's broker, helping to avoid disputes and comply with new buyer-broker compensation rules. Broker's duty does not include assisting in a title dispute years after the close of escrow. Issue: does the brokerage owe a duty to the buyer 18 years after the close of escrow to help resolve the dispute? Answer: no discussion. Because the transaction closed approximately 18 years ago, no common law or statutory duties are owed by the brokerage to the buyer. It is generally recognized that, absent an agreement to the contrary, the fiduciary duties owed by a brokerage to its client end at the close of escrow. See Coldwell Banker Commercial Group, Inkerver Camelback Office Park, 156 Arizabur, 226, 231, 751 P2D, 542, 547, 1988. Recognizing that once an agreement between principal and agent is terminated or completed, the fiduciary relationship is ended, and the broker is free to act for himself or the opposing party, as long as he does not hinder, delay, or interfere with a transaction which the agreement was intended to bring into being. Moreover, assisting in or negotiating a legal dispute is beyond the scope of services which a licensee can legally provide. Accordingly, at this point, the brokerage does not owe any ongoing duties to the buyer, and the brokerage has no legal duty or obligation to assist the buyer in her current dispute with the neighboring property owner. How would an agent receive compensation in the form of a commission at the successful close of escrow if they were working with a buyer and a seller that was selling the property on their own? Buyer's agent should use unrepresented seller compensation consent form while representing a buyer in a FSBO. Reviewed November 2018. Facts: the property is listed for sale by the owner, without an agent. The buyer's agent wants to make an offer on the property for the buyer. The buyer's agent has discussed with the parties her potential representation of the seller. The seller has declined and insists that she does not want or need representation in the transaction, but is willing to pay compensation to the buyer's agent. Issue: is there an AAR form available to assist the buyer's agent in the transaction? Answer: yes. The AAR unrepresented seller compensation consent should be used by the agent. This document will confirm that there is no representation provided to the seller. It also confirms the seller's agreement to pay a commission nonetheless. Arizona Realtor Magazine, March 2014. Here is a look at the Unrepresented Seller Compensation Form, the Unrepresented Seller Compensation Agreement, Arizona Association of Realtors, R., updated November 2024, is a short, specific agreement used when a buyer's agent wishes to secure compensation from a seller who is not represented by a listing agent. Purpose of the form: this form is used when a seller is selling their property without a listing broker, and a real estate agent representing a buyer wants to ensure they will be paid a commission if their buyer purchases the property. Key elements of the agreement. 1. Parties involved. Seller: the property owner, not represented by a broker. Broker: the buyer's agent's brokerage firm. Buyer: the client the broker is representing. It clarifies that the broker represents the buyer exclusively, not the seller. 2. Property identification: specifies the property address to which the agreement applies. Confirms that the seller has legal authority to sell the property. 3. Compensation clause: the seller agrees to pay the buyer's broker a negotiated commission, either a flat amount or a percentage of the purchase price. Compensation is due only if the seller enters into a contract with the broker's buyer during the term of the agreement, or within a specified number of days after it expires. Protection period: Payment is due at closing and is a condition of closing. 4. Agency disclosure. Emphasizes that the broker only represents the buyer, not the seller. A broker owes fiduciary duties to the buyer and must disclose any seller-provided information that is material to the transaction. 5. Dispute resolution requires that any disputes between the seller and broker be submitted to mediation, with both parties sharing the cost. 6. Signatures and acknowledgement. Both the seller and the buyer's agent sign and date the agreement. Seller acknowledges receiving a copy and agrees to the terms. When it would be used. This form is typically used in the following situations: Scenario explanation, FSBO, for sale by owner. A buyer wants to purchase a home directly from a seller who hasn't hired a listing agent. The buyer's agent uses this agreement to ensure they are compensated for their work. Unrepresented seller in off-market deal. A broker brings a buyer to a property that is not formally listed. The seller agrees to pay commission even though they don't have an agent. Custom direct outreach. An agent locates a seller on behalf of a buyer, e.g., direct mail or door knocking, and needs to formalize compensation.